giving evidence to try to establish why he didn't call them when in fact he had the onus to call them and he ought to have, and he has no basis to discredit them and put in his heads of argument with respect that either they're lying or they weren't there. Because they've given a statement, he has the docket, he knows what the statement say. It was put to the investigating officer, Colonel Swartboy, what appears, and he agreed with that. It was put to him that they hadn't seen, they were there and hadn't seen any shooting, and furthermore, had they seen shooting, they would have been obliged to have reported the matter. As is in the heads of argument, and as pointed out by my client, and in my heads, remains unanswered with respect to Worship. Thank you.
Anything else from yourself, Advocate Matthews?
Thank you, Your Worship. I have no doubt Your Worship has correctly recorded what Lieutenant Colonel Janssen said in front of court. So I need to correct, unfortunately, my learned colleague. Lieutenant Colonel Janssen's evidence was that Clement Mhluli and Mr. Boertes were the responsible persons for all of the firearms belonging to tactical security, not accused number 2. We've heard no evidence that accused number 2 is the owner that accused number 2 must have known that those 2 guns were the ones that fired on the night in question. Nothing could be further from the truth. Lieutenant Colonel Janssen testified that as he was leaving tactical security, Larry Mavunda arrived, and he who was Colonel Janssen spoke to Larry Mavunda, who said to him that I believe you are looking for all the firearms belonging to tactical security. And I have brought my firearm. In the further particulars which the state answered, it said the following. On the 6th of August 2018, firearm with serial number SPA 249 was presented to Colonel Janssen by Larry Mavunda. Accused number 2 had absolutely nothing to do with the handing over of that firearm. It was obvious from Colonel Janssen's evidence that he had met up with Larry Mavunda. What of course my learned friend is forgetting is that the police by that stage had already requested that tactical security hand over the firearms that they had in their possession, which were of more or less the same caliber. By that stage, there was already an agreement that tactical security would hand over the firearm in batches to the police. In order to do this, it only makes common sense that tactical security would be calling in all these firearms from every single corner of the Republic, because they are not a company that supplies security only in the Durban area, but throughout the country. These firearms had to be called in, and that was the evidence of Colonel Janssen, that the firearms were being brought in from all corners of South Africa to be presented to the police and to be given to them. Colonel Jansen didn't take Larry's firearm, nor did he take a 9mm from that on the day in question. It was handed into the company and handed over to the police as we have heard the evidence of the investigating officer. Jansen was there in his capacity as the DFO of the province, so that he could look through all the registers to ensure that the company's firearms were in order. He testified that he did that, and in fact they were. So now to attempt to draw this inference that accused number 2 knew exactly which 2 firearms to hand over is simply not the truth. Your Worship, to say, if I'd had more time, I would have charged Larry Mabunda. I don't want to say it again. I can't believe that my learned friend is saying that. In further particulars, before this case proceeded, 2, 3, 4 years ago, the previous prosecutor, Elna Smith, wrote the further particulars truthfully as she could, and she did the right thing. In those further particulars, she mentioned that Larry Mabunda had been issued with that firearm, that he was in East London on the night in question, and that it's alleged that his firearm was the one that had fired the cartridge case on the night in question. She made the right decision because there is no evidence to suggest that Larry Mabunda fired any shots on the night in question. And there is no evidence to suggest that he handed it to anyone. But as we have heard from the cross-examination of the investigating officer, he was asked, why didn't you take a statement from Larry Mabunda? So he didn't want to give one. But they didn't want to use Section 205 to force him to appear before a magistrate and explain the position. So, my learned friend's argument in that regard with respect has got no merit whatsoever. And then your worship would have heard, which is so telling in this case. While he's addressing you, he says to you, the video shows, and he's about to say, accused number 1 handing the firearm to accused number 2. Then he hesitates and says, the firearm shows accused number 1 handing, and then he realizes that it doesn't show that. And he says, we can draw the assumption that he handed to accused number 2. You know what? I can almost go as far as to say, so what if accused number 1 handed the firearm to accused number 2? That is not the charge. The charge is that it was accused number 2 who handed the firearm to accused number 1 prior to the shooting. What my learned colleague is talking about is after the shooting. If this court can say, because there's an assumption that it appears that accused number 2 handed a firearm to accused back, it appears that accused number 1 handed the firearm back to accused number 2 after he had fired it. Therefore, I can draw the inference that it must be accused number 2 who handed to accused number 1 in the first place. Well, I'm afraid, Your Worship, that is not going to do it. Thank you.
Thank you. Just a minute. Sorry, I'm not sure if you were still taking instructions or what is...
Maybe
good.
my client didn't understand. Maybe I should just put it to you this way. You should just hear from the evidence that when Jansen came to do the inspection at TSS, the evidence shows that by that time, there had already been an arrangement that the firearms were going to be handed over to the that's.
You indicated you want to reply.
Just one aspect, I didn't say that it was out of charge, Larry Mabuntla. I said I would have charged accused number 2, but not Larry Mabuntla. And if I did say that, it must have been a slip of the tongue for changing that breech block and for changing the firing pin. Lastly, Your Worship, the issue relating to the witnesses that uses that as the tool of the trade and so on, they are not ballistic experts, so they correctly confirmed that they were not able to say whether it was indeed a real firearm or not. The importance of the evidence here is that of Colonel Guadeka was already mentioned. Bishop, with regard to other issues that was interpreted, my heads are there. Your Bishop, like Colonel Guadeka correctly say, I don't feel that justifies an answer. Thank you.
That is all from anybody. Close this chapter. Okay. Of course, you don't think that it can be expected of me to simply proceed with judgment in this matter right now. I will also consult my diary, weigh the options, and then since we are, I don't know how we'll do that. We'll do it in open court, I assume. So let me just think about it. There's a lot to read. I'll give an example, and I'm not throwing anyone under the bus, but the various statements has been said. You can look in the statements, the words aren't written there. I've perused it thoroughly. Those documents were placed on this bench that day. I also have to peruse and satisfy myself with the contents of each and every document, each and every submission made by the state, Advocate Odes and Advocate Matthews. So I will look at the volume. I don't know, what is the time? I can't see. 11:30. You don't have to, I'm not going to do it today, Advocate Caesar. That is in essence what I'm saying. I just want to come back with an indication of the time frame that I require. So for that purpose, do we stand down now at until 12 for me to indicate?
No issues.
All right. I don't have this thread. He wants asked me to fall down the steps by blinding me so that I can't see the steps. That's fine. Alright. Thank you. Court will adjourn.